Have you ever had interactions with a robot boss? If you ever applied for a job and received a quick automated message saying that you were not qualified for a position, you were shut down by a robot boss. The No Robot Bosses Act is a proposed federal initiative to add guidelines related to the use of automated decision-making systems in the employment context. This proposed act broadly defines automated decision systems, or ADSs, to include any system that uses computation in whole or in part to determine outcomes made or aid decisions, inform policy implementation, or collect data or observations. Companies covered under the No Robot Bosses Act would include any company engaged in commerce or in any industry or activity affecting commerce that employs or otherwise engages individuals for the performance of work or service for monetary compensation. The No Robot Bosses Act would also include certain government agencies. Covered individuals include job candidates and employees being paid money for work or service, meaning that employees and independent contractors would be covered. In general, the No Robot Bosses Act would stop companies from relying exclusively on automated decision systems. In other words, employment-related decisions will require some level of human involvement. The No Robot Bosses Act would also require the following. Employers would be required to train people who are responsible for operating the automated decision system, including inputting data and any appeals processes. The No Robot Bosses Act will require systems to undergo periodic testing of the system to stop unlawful biases, adverse effects, and potential errors or issues with the automated decision system. Employers that use automated decision systems will be required to manage covered individuals and give individuals the right to opt out. Retaliation against a covered individual for exercising rights will be prohibited under the No Robot Bosses Act. The No Robot Bosses Act will provide whistleblower protection for individuals who make a written or oral complaint to the employer or government entity or participate in an inquiry or proceeding under the No Robot Bosses Act. If an employee signs new hire documents that agree to arbitration before there is a dispute or agree to waivers of joint, class, or collective actions before there is an issue, the No Robot Bosses Act will deem these agreements in any form invalid or unenforceable with respect to the use of automated decision systems or whistleblower claims. Finally, the No Robot Bosses Act will require employers to independently confirm an automated decision system's output when making an employment-related decision. In terms of enforcement, the No Robot Bosses Act would give covered individuals the right to start civil action in any federal court of competent jurisdiction to recover actual or triple damages, injunctive relief, equitable relief, and statutory damages ranging from $5,000 up to $100,000 per violation, depending on the circumstance. While Congress has not yet passed the No Robot Bosses Act, employers should stay up to date on any updates and progress regarding this act. You have any questions or thoughts? Let me know in the comment section below. Thanks for watching. If you want to know more about business operations, business management, human resources, and other topics related to running a business, click on one of those play links. Click on one of these click on the playlist.
One eternity later.
Click on one of these playlists. Thanks for watching. And don't forget to subscribe.